Are we waiting for people? I think it looks like people are still, I'll give it 2 more minutes, I think, and before we get going.
Madam Chair?
Yes, is that Joni?
Yeah, it is. I wasn't sure if you wanted us to announce ourselves or if we were going to wait until roll call.
Well, I was just waiting until 1:05, but I actually think, I'm guessing that we could start. Cynthia, do we have, I assume we have a quorum?
I won't know till after we take the roll.
Oh, okay. Let's start then, and then I think we're probably going to be good. But, okay, so let's welcome everybody. Here we are at our February board meeting. I'm going to call the meeting to order, and Cynthia, why don't you go ahead and take roll, and we'll see if we have enough to continue.
Great. Thank you, Professor Torum. Good afternoon. Before I take roll, please note that we're being recorded, and please keep yourself muted unless you're addressing the board. Thank you. All right, Professor Ann Trom.
Here, thank you.
Vice Chair Dave Mendiola.
Present, thank you.
Laura Fitzsimmons.
Present.
Chris June Kiliani.
Here.
Rob Tellis.
Here.
Julie Kavanaugh Bill.
Here.
Joni Easley.
Yep.
Lorinda Wichman.
I am here. Thank you.
Bevan Lister.
Yes, I'm here.
Jeff Wells.
Here.
Drew Christensen.
Here.
Kate Thomas.
I'm here.
And Justice William Moppin. We definitely have a quorum.
Excellent. Okay. And I see it looks like we have some people, I can't tell who they are, and some guests, which is great. Okay. Let's go on to number 2, public comment. Cynthia, I don't believe I saw any written comments communicated by email, but is that true?
That's true. I checked just before our meeting and there's still nothing.
Okay, so we also can have people make comments now. We limit those to 3 minutes. Does anyone have a public comment to make? Okay, hearing none, there'll also be an opportunity for public comment at the end. So if we have any additional people or people who want to say something, then we can do it. The next item, number 3, is approval of the January 28th, 2021 minutes. Anyone have a comment or change to the minutes which were circulated?
Madam Chair, I thought they looked good, and I'll make a motion to approve. This is Joni Eastley.
I knew it would be you, having looked them over carefully. And so that's great. Anyone want to second the motion?
Sure, I'll second it. I did not look them over carefully.
Because that's what you have Junie for. Okay.
No. It's only because I'm old and I actually need to remind myself about what we worked on prior to the next meeting. So.
Well, that's not just that. I have a feeling it's been a habit for a long time. Okay. Everyone in favor of the motion to approve the January 28, 2021 minutes, say aye.
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 Aye. Anyone opposed? Okay, thank you. So let's move to number 4, update by Dr. Mitch Harrian from Soval Solutions. Mitch, are you with us?
Yes, I am. I'm
Oh,
here.
go.
Thank you.
Take it away. Go ahead.
Okay, thank you.
I understand there may be some things that were circulated, but I'll leave it to you to explain what's what.
Okay.
Okay. Thank you.
Sure. So I'll go ahead and I'll pull up the documents that I sent out or that were sent out on my behalf.
Dr. Harrian, before
Yes.
you proceed, I just wanted to give a little reminder to the board that we received funding from the Interim Finance Committee to contract with a data analyst to assist us in meeting the Davis requirements. We did contract with Dr. Mitch Harrian with Soval Solutions, and 2 items that he's presenting today for you are a survey. One requirement of Davis is that within 12 months of the effective date of the stipulated consent judgment, that we must establish a system for issuing client surveys to indigent defendants and incorporating those client survey feedback into defendants' responsibility for reviewing the manner in which indigent defense services are provided by the state. We also contracted with him to create a financial status report as is set forth in our temporary regulation, section 19.3, which discusses that counties have to submit that financial status report no later than 15 days after the end of each quarter. So we did request Mitch to work on those 2 items, and that is just a little bit of an update or a background on what he's presenting today. All of these items have been emailed to you by Ms. Atanasio. If you do not have them in front of you, you can also look at our website and look at attachments, and they are there as well.
Okay. Thank you, Marcy. Before I get started, as Marcy mentioned, I'll be discussing the survey development, and then we'll be talking about the reporting form. I just wanted to talk about the survey. So what we're looking at is a client satisfaction survey. You all may be familiar with the one that was attached to the order from the DC Public Defender's Office. We took a look at that one, but I guess the point is the goal is to develop a survey that allows clients to indicate satisfaction with various aspects of their representation by public defenders in Nevada. The idea is that the results of the survey can identify areas of strength and weaknesses and potentially inform interventions that may need to be implemented at individual or organizational levels. So are there specific attorneys that are consistently below average on a specific question about client satisfaction, or are there specific offices that might be above or below the average on specific questions or specific aspects of satisfaction? It's not to say that this is meant to be sort of a corrective type of tool. It's just something that can help you all inform where you may be doing well and maybe not doing so well in other areas. Okay, so when it comes to developing the survey, we have several options. The first option, any organization, if you're going to develop some sort of client satisfaction survey, you can start from scratch, develop your own survey, kind of think of the questions that you'd like to ask. Something that we had called face validity. So if you want to know if your client satisfaction, your client satisfied with the timeliness of the representation or something like that, you can develop a question that asks about that. But in the absence of having that expertise, the survey development expertise in your office, it's maybe not always best practice to develop your own survey. Okay. So the next best thing is to look at other analogous agencies. So agencies analogous to DIDS or public defender offices in Nevada, to see if they've developed client satisfaction surveys that you might be able to borrow and adapt for your own purposes. And that is something that's definitely a possibility. And Marcy and her team and I, we did discuss that option. You know, again, we looked at the public defender service, the DC public defender's office. They have a 2018 satisfaction survey. And that was an option we definitely looked at. We drafted a couple of surveys that was based on, or that were based on that document. We looked at it, we thought about it a little bit more. We dug a little bit more into the literature, into the academic literature on the subject, and identified several client satisfaction surveys that have been developed and peer reviewed in the academic literature. So these are surveys that have been developed by researchers, validated against objective outcomes, and have been peer reviewed in a peer reviewed journals. So a couple of the surveys we looked at, again, the Public Defender Service survey we looked at. There was a paper in the Ohio State Journal of Criminal Law that I reviewed that had, I think, a 24 question survey. Again, I couldn't tell on that one if it was peer reviewed or not, and it was relatively long. I got into, again, the peer reviewed literature a little bit. Behavioral Sciences and the Law is a journal that, as the name of the journal suggests, does a lot of this work. You know, kind of legal psychologists published in this journal. And we found a couple of articles there. There was one article that was not specific to public defenders. It was a client attorney scale of satisfaction. But we did identify a scale that exists in the literature. The article is called Unnoticed, Untapped, and Underappreciated Clients' Perceptions of Their Public Defenders. It's in Behavioral Sciences and the Law, year 2015. The survey is short. It's 10 questions long, but it hits some of the concepts that we're interested in terms of measuring clients' perceptions of fairness, timeliness of representation, things like that. We liked this survey because it had been peer reviewed. It is in the academic literature. It's relatively short, so it reduces survey fatigue. And it's going to reduce, so by reducing survey fatigue, it's going to do a couple of things. So first, respondents are less likely to just not answer it. So if you see if you've taken surveys before, so if you have a long survey in front of you, you may be less apt to complete it if it looks like it's going to take up a lot of your time. Or if you do begin to answer it, you get halfway through, you get tired of the questions may seem repetitive. You know, some research has shown that respondents may just begin to check, you know, option C or something like that for every question. So having a relatively short survey, we thought, would reduce the error that would result from having that sort of those sorts of problems. And Marcy, do you think I should pull the survey up, or do folks have this in front of them?
They were given a copy of it. I don't know if we could probably ask Chair Trom if she'd like to have it pulled up on the screen.
I don't think you need to pull it up. I enjoy seeing people's faces. Sometimes I think that's easier, but I do have a few questions. I'm sure that other people may too, but.
Yes,
sure.
I also.
So go ahead. Is that Joni?
Thank you, Madam Chair. It is just a really quick one. I don't know if this was important to anybody else, but speaking as a representative from a frontier area, I would be very interested in if the survey included a question in terms of how the defendant met with their attorney. Was it in person? Was it over the telephone? Or was it on a video camera? And we certainly don't need to modify the survey to include that information because I kind of notice everything fits in there very nicely. But I think for the frontier counties, we might be interested in seeing whether or not those attorneys, and let's take Tonopah for example. If the public defender actually drove up from Las Vegas to Tonopah to meet with their client, or if they talked to them on the telephone, or I'm just interested in those kind of things.
Okay. I think that would be a good question to add. I think assuming we don't add too many more questions, that wouldn't dramatically increase the length of the survey. But one thing I do like about that question is down the line, if you look at the cover letter that was sent out with the agenda items, I do describe, some of the things I just mentioned about survey development. Then we talk about survey administration and the analytic strategy. I think that question would be a good one potentially down the road after you get sort of a critical mass of survey respondents in 1 or 2 or 3 years, whatever it might be. That might allow you to look at that question and see whether levels of satisfaction differ based on whether they met with their attorney in person or not. So I do
and
like
that's exactly why I wanted to know. Yes, thank you.
Yeah, you bet.
Do other people have questions? Rob, tell us. Go ahead.
Thank you, Mitch. On the survey, you see the last few questions that are, I guess for the purpose of demographics, on those questions it says paper version only. I'm sorry, I didn't see where it might have said why that was the reason, if there's a law that prohibits us from taking that electronically, but just curious as to why that might be.
Yeah, so it gets into the survey administration. So how are we going to get the survey to folks? So we plan on having 2 survey methods or survey modes. So one is going to be electronic, one is going to be pencil and paper. So for the electronic version of the survey, what's going to happen, or what right now the plan is that the survey will be administered to folks through Legal Server. So they'll be able to push this out via email or text message to clients. And in that case, we will already have that demographic information about those folks. I suppose we could ask those questions again in terms of age, gender, nature of their case, but we'll have that information in a database that we'll be able to link their survey responses to. So that was the reasoning behind only asking the demographic questions on the paper and pencil version. But it'd be, I don't think, any problem to include that on the. I actually meant to delete that before I sent this out, but anyway, so we could have that redundancy built in just so we have that same question across all surveys. So that's definitely something that Marcy and her team and I can talk about.
Yeah, I think that might be important, just to verify our data. Again, you never know, during input, something may have been incorrectly input, who knows, but we'll have it in this person's own words on the survey.
Okay.
Thank you.
I appreciate that.
And I think you're on mute.
Yes, I got it. I figured that out. Do other people have questions?
I just had a generic one. I'm curious why we didn't have a column of either don't know or not applicable. I realize in some questions that folks gonna know, but did my attorney look into the prosecutor's evidence? They're not gonna know necessarily. They might know. And then my other question was, my attorney investigated my case. Perhaps it should be my attorney or his staff investigated the case, because lots of investigations are not necessarily done by the attorney, but they actually retain an investigator to do it. Just a couple of thoughts like that.
Okay, that's a good question. When you see surveys like this, so if you're looking at the survey, let me see here. And you see on the questions, we have response options that range from strongly agree to strongly disagree. These are called the Likert type scale. So if maybe you've heard of that, maybe not. But sometimes you will see an NA option at the end of those, or a do not know option. So that is something we can consider. And the other option is for the respondent to respond with neutral is another way they could go. But yeah, I mean, it's something to consider. It's like a judgment call whether or not you want to include that. But it is good in terms of the questions that you referred to, where the client may not know whether their attorney did something or not. It may be good to add. But if we do add, I would recommend adding it to all those questions.
Oh, yeah, no, I just use those as
Right.
examples.
Mhm.
And Marcy, is this survey going to, I didn't study it enough, is this going statewide or just rurals?
This is required pursuant to Davis, so the plan is in the rural counties.
Okay. The only reason I asked this question too is after your arrest, how many days was it before you saw your attorney? And down here, because we're using the IA court, the question should be how many hours was it before you saw your attorney? But if it's only going out in the rurals, then days is fine.
Okay, other comments on the survey? I do have like just one or two follow-ups, I think. One is I gather from what I'm seeing here that this is not anonymous. Obviously, that might be already tagged if you're doing it like it's being pushed out by text. But if you're doing the paper version, is there a place where people write their names? And then, so that was one question. Another question is, I assume this will be in multiple languages if needed. We'll have it there. And then at the end, there's this some disclaimer that we do have I just wanted to know your thinking on this. Like, we do have a process for complaints, but I'm not sure if like what your thinking was about just other comments. People might want to say something that's other than a complaint. Like, there might actually be a compliment or just an observation that people might want to have the freedom to write something in. So I was just curious about that.
Yeah, we went back and forth on that a couple of times actually. So, you know, if you looked at a previous version of this, there were some like, it looked like notebook paper, you know, where they could add some comments. Like I said, we went back and forth, and I think the kind of where we landed before we sent this out was we didn't necessarily want people to use this as the complaint box. So I think, Marcy, you can correct me if I'm wrong there, but I think that was kind of the thinking on that.
We already have a process for complaints, correct?
Mm-hmm. Yes.
Right. I guess it seems like I was just curious about, people might say things that are not complaints, like they might just be random comments, right? So, and people are, I can see leaving it off, but I just, but I can see leaving it off, but people are used to reviewing things. Like, they're used to saying, like, many people are used to sort of saying their piece on something, good or bad. So anyway, I was just curious about that. Okay, that's helpful. Anyone else? And then when are you expecting this to go live? Like, what is the timing? Or whether you or Marcy know, I don't know.
This is Marcy, so I don't know if the board would like to approve it today with the recommended changes that have been discussed, or if you'd like us to make those changes and bring it back one more time at the next meeting. Our deadline is next August.
Oh. And
we can roll it out. Our plan is, I think Mitch talked about it, we could use Legal Server to roll it out, which we believe Legal Server should be rolled out sometime in April fully. So we would roll it out at that time, and then we are looking into, you can see on the paper survey, we're trying to have it so that the postage is prepaid. So we need to look into that as well. And then once it's approved, we'd have to look at translating it to different languages. And I don't know how many languages the board would like it translated to, or if we just like to limit to English and Spanish or more.
Madam Chairperson?
Go ahead.
This is Julie Kavanaugh-Bill. I just wondered, I was going to ask Marcy or Patrick if it was sent out to the rules and if we had any comments from them.
This is Marcy Reba. In response to that question, we sent this out to all interested parties that are listed, and we've put it on our website as an attachment. So if they're an interested party, they would have received a copy of it.
Hi, this is Laura. I'm fine with it just going. I'm kind of surprised that this is already that the board's this involved. I think it's great what you've done. You're thinking about it. I think everybody's seen it. If everybody's expressed suggestions and concern, I don't feel it would need to come back to us.
I agree with you. Let's just get it done.
Great. So does someone want to just move to approve the survey? Blessed survey.
Madam Chair, I'll make a motion to approve the survey with the changes that were recommended during the discussion period.
This is Rob Bass. Oh, Jeff. I'll second.
Excellent. Everyone in favor of the motion to approve with in light of the discussion?
Madam Chair, can we just have a tiny bit more discussion prior to calling for the vote? I just want to review one more time what the changes were. I know what mine was, which was how did you meet with your attorney? What were the other changes, just so I'm clear?
I can go through my notes here. So how did the defendant meet with the attorney? Add demographics to the electronic survey as well as the paper and pencil to make them identical. Add a don't know option to the Likert scale questions, a place to write their names, and then a place for notes and comments. I'm not sure where we landed there.
I don't. Yeah, I mean it's a comment. It's not a requirement, or okay. No, it's not a request. I defer to you all. Okay.
And then in terms of multiple languages, I don't know what we have to decide there. But those are my notes.
Yeah, I don't have a problem leaving that to staff's discretion. I do have a question for Marcy. Marcy, do you want me to amend my motion to include how we're going to roll this out, whether it's going to be on legal server or by some other means, or is that more appropriately left to staff's discretion also?
We would ask permission to have it be left to staff discretion. We are looking into the paper version and the cost of prepaid postage. At this point in time, it's not necessarily built into our budget, so we are looking at our budget to see if it's something we can work in. So we'd ask that it be left to our discretion, and that is our plan at this point, unless our budget restricts us.
I think it would be worthwhile maybe for the paper versions to reach out to individual counties and see if they might not cover the cost of that. Just a suggestion. But Madam Chair, my motion stands, and if you want to call for the vote, that's great.
Yes, okay, I'll do that. So everyone in favor of the motion as we've discussed? Everyone in favor say aye?
Aye.
Aye.
Aye. Anyone opposed? Excellent. So thank you all for doing the survey and for pushing it out. And yeah, we'll look forward to see what it brings back. Okay, let's move on to just see back to my agenda. So item number 5 is temporary regulations. So I'm going to hand it over.
Chair Trom, Ms. Cherion had one more item to discuss, and that's the fiscal reporting form that he would like to propose that we need to get rolled out.
Forgive me. Go ahead, Dr. Harriet. Sorry.
Thank you. So yeah, you should have received this along with the agenda items as well. So the financial reporting form will be sent out to rural counties to inform reimbursement for indigent related defense. So if you have the form open, you're taking a look at it, really what we did was it's a simple Excel file with a tab for instructions, a tab for each of the 4 quarters of a calendar year, and a separate tab for separate death penalty case related expenses. On the instruction sheet, really what we tried to do here is give the user, the respondent, detailed instructions on how to complete the form, really focus people's attention on the fact that we're looking for indigent defense related services. So this may require folks to break out certain expenses that they may tend to report, I guess, in aggregate, trying to find the proportion of those that are for indigent defense services. We provide a little bit of detail on the various categories we are focused on. And I guess I should mention that we are aware. So what I did was I took a form that Jason Colnut had put together earlier. I adapted that for this purpose. And, just based on his experience, there's going to be wide variability in counties' ability and or willingness to report some of this information. So we understand, based on past experience and just what we know, that this may be difficult information to obtain at first, for sure. But we're hoping that we need to make it clear that this is to the benefit of the counties to report these expenses. So it may be painful at first, but hopefully down the road, after they've had an opportunity to go through this process a couple of times, it gets easier. So I don't know how much I need to get into the various tabs, but if you were to open up tab 1, the Q1 2021 tab of that Excel file, you can see what this form will look like. So we're just asking an individual to state who they are and then report the expenses that we're asking for. Yes.
Hi, this is Laura Fitzsimmons. Have you sent this out to the county managers? See,
No.
that would seem to me to be not, I don't want to get into another, whole thing about who's using what software, but it would seem to me that they would know, the people who are going to be filling out these forms should provide input. I mean, I have no opinion, and I have opinions on lots of things. I would just like to suggest that maybe if you have time, depending on when your deadline is, that you just send this, because is this also just going to the rurals? The day? Yeah.
Yes.
I don't know. It seems to me they would know better than a lot of us would what works.
Yeah, and we have discussed that definitely, just to understand the feasibility of them providing this information. So I think the way I would talk about it, I would say, let's pilot this thing. Let's send this out for kind of a test run, send it to a couple of folks that would potentially be filling this out or have that level of knowledge, and let's figure out if this makes sense to them. And if it doesn't make sense to them, we may need to amend it. So I would certainly agree on that point.
But I think there was a slight, I'm saying send it to all of them. Everybody you expect, not just pilot it and pick a couple, because sometimes, they may, when they look at it, they may not understand what this category means. And then there can be a conversation beforehand. But I mean, I would assume that there's a variety within the counties and their managers and how they keep their records. Maybe there's not, but I also think it might be kind of polite.
Yes, and Chair, may I make a comment? This is Marcy Rivas. So it's very consistent with the form that was sent out previously to all of the counties when they were reporting their fiscal year 18 and 19 expenses and their expected 21. So they've already filled this out. One thing that we're going to have to work with them is separating the indigent defense expenses from all other expenses. And that's something that when we go and meet with them with the plans and showing them the form, that's what we're hoping to really let them know, that this is limited to indigent defense. And then just for the section, this is as required in section 19.3 of our temporary regulations. So it's all counties. Clark and Washoe did use this to report their expenses as well for fiscal year 18, 19, and fiscal year 21. or a similar one.
Madam
Okay.
Chair,
Yes, go ahead.
Dave Mendiola. So yeah, I would, with respect to sending this out, you know, there's two ways to look at it. There was a time when we were all in the rurals under one system called ADS. It would have been really nice. Everybody could put the data into ADS and could have easily gotten reports, but that's all changed now. Everybody's on disparate systems. So what I would recommend, since the staff's going to go out and meet with the counties, that they meet with the comptroller, the county manager, and the PDs or contract folks, whichever the case may be. And at that time, go through not only the plan, which I know is part of the strategy, but also this spreadsheet. And Marcy's right. We've already filled these things out. Everybody's familiar with it. And I think because everybody got a different software system, it's going to be highly unlikely they can produce it out of their software. But filling a form like this out is pretty easy. So that's my comments. Thanks.
That's great. Okay. So I guess my question is this something that we need to approve right now, or is this just an update that doesn't require our approval?
I don't believe that you necessarily need to approve it right now. We can roll this out to the other counties. We are planning on trying to get on as many county board of supervisors meetings as we can to introduce ourselves. And this can, as Mr. Mendiola did discuss, we can start meeting with the fiscal staff for the counties as well and talk to them. I think that's a great idea.
Okay, and also my question wasn't meant, do we need to approve it? I guess my question is, do we need to approve it at all? If we need to approve it at all, my sense would be that we would be happy to approve it, you know, sort of so that it can get out and you don't need to come back to us with whatever tweaks you're making that incorporate feedback you're getting. But I don't mean to say that you should come back later. If we need to approve it, we should do it now.
Section 19.3 says the financial status report shall be in the form approved by the department.
Board.
Or board.
Oh, okay.
It says
So
department.
can I make a motion to approve it? Laura Fitzsimmons, is this a good time to just make a motion to approve the form?
I think so. Jeff Wells, do you have a comment? It looks like you're about to say something.
I just have a question. If this is going to apply to the larger counties as well, is there a significant reason why we can't split it up between offices? If I lump my Office of Appointed Counsel and my Public Defender's Office on here and merge investigations and experts, it won't give you a clue as to what we're really doing between the contract attorneys, conflict attorneys, the offices. Can we give it to you in 3 separate forms? That was one from the public defender, one special public defender, one the Office of Appointed Counsel.
I think the answer is yes, that's a good idea.
All right, then I'll second Laura's motion.
Any other comments before we take a vote? Okay, so all in favor of the motion to approve the quarterly financial status report as we've seen it, sort of subject to sort of tweaks and feedback as you're moving through the process. Everyone in favor say aye.
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 Aye. Anyone opposed? Okay, so that carries. Thank you so much, Dr. Harrian, for doing
Yeah, you
this
bet.
with us, and
you.
to the department for getting all of this going to comply with Davis. That's great. Okay, now I think I can move on to number 5. So the number 5 is on temporary regulations. I think I'm handing it over to Jared Hickman to give us an update and covering A and B on the agenda.
Yes, that is correct. Thank you, Madam Chair. Jared Hickman for the record. To start off, before we get to 5A, just as a reminder, temporary regulations are anticipated to be effective absent any formal objection filed on March 5th. And that's the day that they'll be filed with the Secretary of State absent objection, 35 days from the date that the board approved the temporary regulations last month. So with that in mind, we're moving to 5A, which is a question of the due date for initial county plans for the provision of indigent defense services. Anticipating that we might get the regulations approved or effective either shortly before or right after the statutory May 1st deadline, we included in the regulations a provision that allows the initial plan to be submitted within 6 months of the effective date of the regulations. So although we have August 6th listed, you'll have to excuse our math error. That's actually September. It'd be September 3rd would be 6 months for that. The issues that we're facing, just to provide a little description as to why the September 3rd date is preferable to the department, are this. We've still got several components of the plans that are not up and running, and I think very important or integral to the plans. The first is Legal Server. The case management data reporting software is looking like it will be ready for training and rollout at the end of April. We had one slight hiccup regarding partitioning counties from each other's case management systems that has required essentially a change order. And that change order has to go through the contract process with the state. So they're estimating 6 weeks after payment, and we are still waiting approval, state approval for the payment of the work order. We are slated to begin kind of small office test runs for specific processes to get county feedback as to what, say the intake process should look like. And that way that'll inform our setup up until the go live / training date. The second issue that we have deals with the workload study that has been identified as probably the most important or most central part of what this board and department does. We are 2 weeks away from completing the time gathering component of the study. After that's concluded, NCSC, the National Center for State Courts, will analyze the data and then is anticipated to begin the Delphi or the expert process sometime in April, which puts a draft report available in the middle of June. And the workload, any workload guide or workload maximum that is determined from that study would be a central component of any plan or contract. And then on top of that, we are still going through the budgetary process with the legislature, and I think that's also an integral component in forming plans as we identify cost of compliance with regulations. So those are all issues that I think support looking at that September 3rd date. It gives us more time for planning with the counties. I think there's also a logistical issue in the 2 months between March 5th and May 1st. It's going to be a really tall task to get out and get in with every single county to assist in plan development. And we'll talk more about that plan when we get into the county plan template in the next section. But that is our request is we're asking that the board approve the initial submission of those plans be the September 3rd date.
Chair Trom, you're on mute.
I got it. Sorry. It's just my hands are not as fast as my eyes. Okay. So any comments or questions about that? Okay, I think we could, so are we going to approve something in Part B? Are we approving those forms?
There are forms, and yes, we'll be asking for approval there as well.
Okay, I feel like we can hold off on this and just do the whole slate of things that we'll do the deadline with the forms, since that's all of a piece.
Okay.
Is that okay? So let's, Marcy, are you going to report on, no, you're both reporting on B.
Correct.
Keep going if that's what your plan is, yeah.
Okay, so the next thing that takes us to is Part B, the forms. The first form we'll take a look at, and I'm just going to provide a generic description. They have been provided in the materials I won't go on a section by section, but we'll certainly field any questions if the board has them. The first form we're looking at is the application for the list of qualified providers. It is a paper copy has been provided. It is modeled after existing applications in both Clark and Washoe County for their appointed council programs. It is applicable only to contract or panel of appointed council attorneys. It is not applicable to public defender offices. It will be available through our website. The plan is to put the link for the application on the website for ease of submission and in a central location to file it. It essentially focuses on the qualification requirements that are within the temporary regulations and gives us an opportunity to review those for inclusion on that list.
Okay.
The next document is the plan for the provision of indigent defense services template. If the board recalls, it may almost be a year ago to the day, we created our first draft of what a plan for the provision of indigent defense services might look like. The comment that we got back from that draft was that it was A, confusing, B, left little room for county choice, as the document was essentially pre-filled, to a large extent, and that it should be, more simplified into kind of a plug and play or fill in the blank format. So heeding that advice, this particular plan template seeks to do that. It identifies the major sections that are consistent with the Nevada Supreme Court model plan issued in ADKT 411, the two urban model plans from Clark and Washoe County that were submitted in ADK 411, and the federal, the Ninth Circuit Criminal Justice Act model plan for the provision of indigent defense services. In each section, there is instructions that describe what should be included in that section, as well as a bank of applicable statutes, regulations, and other guidance. So these specific areas are identified and can be quickly and easily found. Our plan, which we've already started to implement, is to reach out to each board of county commissioners to do and get on agendas to do an introduction to the temporary regulations and the plan process. We will review the plan template with the Board of County Commissioners. You'll also see that I have attached those two documents, two of the model plans, as an appendix for additional guidance, and then schedule follow-up so we can assist in creating the plans in accordance with our statutory obligations. So that way the county has time to be introduced to what it is, what it means, what we're after, take a look at it, develop questions, and then utilize our assistance in completing the document.
And if you're ready to move on to the next document that we have proposed is the standard contract for indigent defense services. Just a reminder, Davis requirements say that the executive director shall establish a standard contract for the provision of indigent defense services, and this is required to be completed within 6 months of the effective date, which is approximately February 11th, 2021. We were instructed to use the National Legal Aid and Defender Association's model contract for the public defense services as a model, amending as necessary, and to ensure consistency with AB 81 and implement regulations. Some of the requirements that are set forth in Davis, one requirement is that the contract should have a requirement that any applicant who previously served as a county prosecutor shall not be eligible for an indigent defense contract in the same county before 18 months of their last employment date. We are proposing moving that requirement.
One is interesting. Sorry, I thought I was muted. Sorry.
We are proposing the department is allowed to waive that because we still have that conflict check language in there. But we are proposing to move that to the attorney application form, which Jared originally discussed, rather than placing it in the contract. One change that we do request to make, or that I would be making to the standard, is to add a signature line for the department at the bottom of all these contracts. Pursuant to the Davis requirement, all new county contracts must be approved by the executive director or a designee prior to execution. So the only thing that we would add is an instruction box that cites Davis that we have to approve all of these contracts for these rural counties, and then to have a signature line for our department that we approved it. As you can see, what we did is we basically put black boxes, much like is reflected in the model plan, where we took the model contract and we just told them certain language that needed to be added in there, and we would cite the regulation section that discusses, what you need to make sure that you cover and what's required to be in the contract. We did send this form off to the Attorney General. We met with them yesterday and had a thorough conversation, and changes that he recommended have been made. So what we are submitting to you now is our standard contract proposal with the addition that we add that signature line for department approval of all contracts.
Okay, comments from the board? Questions?
Yes, Madam Chair, I have one question for Marcy. Marcy, as long as the county meets all of the requirements or matches the language in this draft or standard contract, do they have some latitude about, and I don't even know what these would be, but including things that might be peculiar to or specific to their county?
I believe Jared wants to answer this question. Oh, you don't want to? He's mumbling here.
Sorry, I can't. Yeah, the answer to that is yes, there is some latitude.
Okay.
I think the language of Davis, although recommending the NLADA model contract as a guide, specifically references changes for county particularities.
And I
Okay.
think this is Marcy again, just to back that up. That's part of the reason we did the regulations section 42, because we wanted to give the counties the authority to make their own contracts so long as they include the required language that's set forth in the temporary regulations.
Okay, great, thank you.
Anyone else have questions or comments on?
Madam Chair?
Oh, I see Drew Christensen. There was a hand.
And Julie.
Oh, and Julie. Okay.
Thank you, Professor. Marcy, I just had a question. What's the typical contractual period for most of these counties? And are we going to do them on fiscal year cycles, calendar year cycles, 2-year cycles? I didn't get a feel for what people currently do and what was the anticipation of what we're doing.
The answer to that is it depends county by county. Some counties are doing a year starting July 1st to the next June 30th. I know that there's one county that's done a 5-year contract. I believe other counties are in 2-year contracts. So we have received kind of a question of what if we're in the middle of a contract period and these regulations come to fruition. We had a discussion with the Attorney General yesterday and received some guidance. We may have to talk to the counties about a contract modification to include these requirements. But that's something that we are looking into to make sure that we are complying with. But not everyone's contracts are on the same schedule.
Okay. All right. Thank you.
Julie, are you there still?
Thank you, Madam Chair.
Sorry.
Yes, I am. Can you hear me?
Yes, thank you.
Okay. So on the attorney application, and I think that was Jared talking about that, I know when we first were looking at what the requirements would be for the different categories, say for the category B, there had been some change in the language in the actual regulations to make a little more flexible, because the concern was, and I actually have received 2 comments just this week on that particular form. The concern is that in the rules, we were limited on the attorneys that will take criminal appointments in the first place.
Yes.
And oftentimes a lot of our cases, and our felonies in particular, don't go to a full trial. I don't know what the percentage is, but the concern was if we say you have to have completed or substantially been involved in 3 felony trials before you can take a category B. I don't know how many attorneys that would leave us with.
Sorry.
And so I don't know, I encouraged the people that commented to me to make comments to the department. I don't know if they did, but that's a concern. I'd hate to leave the judges with, 0 to 1 attorney that's applied to take those appointed cases.
Thank you, Board Member Kavanaugh Bill. I guess in answer to the last question about whether or not anyone's provided the department with contact or comment, the answer is no. Addressing the first concern about building flexibility into the temporary regulation and the application, the answer is yes. That was certainly done in each of the regulations dealing with qualifications, and on page 3 of 5 in the application, there's a section entitled qualification based upon equivalent experience and skills. And it reads, attorneys may seek to establish qualification through equivalent experience and skills. Those may include, but are not limited to, misdemeanor jury trials, bench trials, preliminary hearings, clerkships, internships, trial college participation, et cetera. So we do have that flexibility built in to review to account for that very eventuality that you described.
Okay, and if I may, Madam Trump, just one.
Please go ahead. Please go ahead.
So maybe, thank you. So maybe on the I think it was on the first page where it has it. I just pulled up another document, so I don't have that one in front of me. But maybe when it first asked for that, we put an asterisk and have them also see that section. Because some attorneys, right when they're filling out the application, they may look at it and go, oh, I'm not qualified, and then finish it and not finish it then.
Okay. I think we can do some. We can either move that up or include a note under that section to direct any applicant to that section for alternative qualification.
Okay, thank you.
Thank you.
All right, other comments on these documents?
Well, I have a couple.
Go ahead.
I do want to thank Marcy and Jared on the draft, or the template, if you will, for the standard plan. One of the things I have said for the last, 12 or 15 years, however long the Supreme Court's Indigent Defense Committee was going, is that, one size doesn't fit all. So I appreciate what they've done by just putting the topics in that they want covered and moving forward. When I get to this last contract, the attorney contract, or the standard contract that they would be signing, I'm concerned about a couple of things that look like it's in conflict. You've got paragraph 7 that basically says oversight of both the contracting authority and the contractor will be by the department. So you have the county entering the contract, but now oversight of the performance, if you will, of the lawyer is now done by the department. And then when you get into paragraph 15, there's an implication in there that even if the county wants to have a corrective action against the contractor, or if the county even wants to dismiss them and move on to somebody else, it almost looks like the department is trying to take over and say they're going to tell the county whether they can do that or not. Now, perhaps I'm overly reading that, but the combination makes it look like it's going to be very difficult for a county without the permission of the department to terminate a individual contract. So I guess my question is to Marcy or Jared, is if I'm reading that incorrectly somehow.
And I think that that language was modified to add our department into it. We could remove in number 7, oversight of the contractor. This language was modified to make it fit to our department. We could go back to the model contract language for both 7 as well as 15.
Okay, that might make it better. Or at least solve my problem.
So I
So, Madam, this is Bevan Lister.
go ahead, Bevan.
So I'm still new enough to this, trying to figure stuff out. But wouldn't it be more effective to have a set of items that the counties need to have in their contract with their public defense contractor, rather than have you write a contract that we may or may not like? Anyway, that's just one thought. You know, if you give us the things that need to be in the contract, then let us have that contract written and agreed to. The other thing is I'm understanding that all of these new reports, all of these new requirements, all the stuff that we're putting in place here is only applicable to the rural counties, and Clark and Washoe, I guess they have their own system, so they don't apply to them.
Okay. Thank you, Mr. Lister. We're getting some feedback there, but Marcy and Jared, do you want to respond to those questions?
So as for the contract, we do agree with you, Member Lister, that we wanted to set out what was required in the contracts in our temporary regulation section so that counties would have the ability to make the contracts fit their county. So as long as they have these certain things, they do not need to use this model contract. It is just there for them to be able to use. And it's also required pursuant to the Davis lawsuit that we have a standard contract for indigent defense services, which could be used by the counties. So our original intention was to just set forth what was required. But because of Davis, we are also providing the standard contract because we are obligated by the terms of Davis, and there is that deadline for February.
And then with respect to your second concern, Mr. Lister, the Davis settlement agreement applies to rural counties, specifically rural counties that were providing the service by contract attorneys. And so that is, the first reason why an abundance of the regulations apply to rural counties only. The second reason is that the urban counties, Clark and Washoe, have already undergone this process in ADKT 411 and have formulated and submitted model plans to the Supreme Court, which contain, in substance, the very things that we're setting out to accomplish via the regulation for the smaller counties. Those plans are on file and made public in the Supreme Court ADKT 411 docket, and are able to be reviewed. They contain the same, they contain the same push for the independence of the defense function, qualification requirements, which are generally, I think, more stringent than ours, as well as the discussions on payment and in some instances, data collection.
Okay. Additional comments? Okay. So I only have one comment, which is just that paragraph 7 on the, so my understanding it was those black boxes in the standard contract form were sort of the guide. If you're writing your own contract, you have to put in these things. Is that correct?
No, the black boxes were added by our department, specifically referring to our regulations of what you need to include in those portions.
Yes. Okay. So those are the must includes. And then this is the entire contract is just a template that you can use. Okay. And then just like one little thing on the oversight comment that Jeff Wells made on that paragraph 7, it's possible that just oversight just might not be the word that you want to use. It's sort of like subject to review is maybe another option that kind of captures the statute goal, but has less of an oversight look and feel to it that may actually just not capture what you're kind of doing. So All right, so do you feel like you have the feedback that you need from the board in terms of any minor changes or comments? It seems like there are very minimal changes, if any. Okay, so we could entertain a motion to approve the September 3rd date for submission of the county plans. So that's September 3rd, 2021, and approval of these 3 different forms that we've just been discussing: the attorney application to the department, the model plan template, and the contract template. Would someone like to make that motion?
This
I'll
is
make
Chris.
the
I'm
motion.
happy to.
Go ahead.
Go ahead, Chris.
Chris, I'll restate exactly what you said. My motion would be.
That's what I was going to say. I'll second it.
Excellent.
All right,
Okay.
great, Drew.
All in favor of approving those 4 items that I just listed, the date plus the 3 forms, say aye.
Aye.
Aye. Anyone opposed? Excellent. Okay. Thank you so much for doing all of that work and pushing it out there. Yeah, I'm sure hopefully it'll be very, very valuable and make the county plan process more streamlined, right? Everyone kind of knows what's happening and knows what to do, and it's not overwhelming to them. Okay, number 6 on our agenda, update from the department. Can't remember whether Marcy or Jared is doing that. Okay, Jared, go ahead.
Thank you, Madam Chair. I'll be handling that as well, Jared Hickman. The first thing, these are all discussion points only. The first thing, I guess, kind of a pre-subsection A is we do want to inform the board that we were able to hire our second management analyst focused primarily on the analytics of the department. His name is Stanley Morris. He started approximately 2 weeks ago and has fallen right in with Patrick working on the legal server reporting. So we do have a new team member, and hopefully in sometime in the near future we can.
Uh-oh.
I think they froze.
We're not hearing them.
Yeah. Let's just give it a second. They might also just hop off and hop on, or I don't know what to do here. I'm hoping we don't have to all hop off. I don't think so. Cynthia, are you there?
Yes, Professor Trom, I'm here.
They lost their broadband.
So I'm wondering, Cynthia, if you have any sense of whether you're in the office with them and have a sense of whether they're.
No, I'm not. So it's got to be the office. Let me send her out a text and let her know.
Okay, thank you. Oh, this is Lexi?
Yeah, I just sent Marcy a message.
Okay. I mean, I suspect Cynthia is the organizer, so it seems like they should be able to hop back on or call in if necessary.
Yeah, I
Can
think
you
they.
hear us now?
Hi.
Hi. This is Marcy. We're back on.
Okay, great.
Yeah.
As you were saying.
where did I get cut off? Had I finished talking about Stanley?
You just said we got a new team member, Stanley Maurice,
Yeah.
and hopefully, I think you wanted to say we'd see him.
Yes. Hopefully, at our next meeting, we'll be able to introduce him with a face to the name. The second part of this particular section is the National Association of Public Defender Grant Award for our newly implemented SOAR program. SOAR stands for Support, Outreach, and Assistance Resource. There is our flyer or promotional flyer, no pun intended, is in the materials, but essentially the goals of this program are to provide attorney mentor, case brainstorming, and research resources to practitioners in rural counties, and at the same time generate law student interest in and exposure to rural practice. I won't belabor the procedure for requesting the services of SOAR. It is in the materials, but I would point out that we have our first meeting this Friday, and we're very excited about that and look forward to having a successful program. The other part of that is we were awarded a grant of $3,000 for this implementation, and we're using that to get the essentially materials that we need to facilitate the meetings over, over a vast distance. So the Zoom licenses or WebEx licenses, any research materials needed to accomplish the task that the groups set out. But we are very excited about our first meeting on Friday. The second activity of the department that we are doing right now is in compliance with the Davis settlement, working on the motion bank or law bank. We have formed a committee to discuss the creation of this resource that meets essentially on the first Monday of every month. Rather than the traditional brief bank, due to concerns about essentially it becoming a copy and paste bank, we are developing a trial practice resource in the vein of the Georgetown Law Journal Annual Review of Criminal Procedure or the Criminal Practice Institute Trial Manual. The group that is working on this particular task consists of John Lambros, Julia Murray, who is the training director in the Clark County Public Defender's Office, and a group of 6 law students from UNLV Boyd School of Law. We had our first meeting this week, and we'll begin piecing that particular resource together. And as soon as the initial chapters are completed, we'll be providing that as a resource. And then continuing to move forward until it's completed and then needs updating.
All right.
And this is Marcy. The only thing I would add is, again, in Davis, that's one thing we are required to do is to make training and guidance resources available to all indigent defense providers. And then such resources should include experienced criminal attorneys available for consultation and a brief and motion bank of pleadings. So in meeting that obligation, that is why we're taking these steps.
Excellent. Okay. Thank you for that. Any questions on just the update on SOARs and the work? It's exciting. This is a lot of stuff, and I think the response in the rurals to getting this additional help and support and building community and solidarity is already happening, and it's just going to be more sort of robust and yeah, just really helpful for everyone involved. It's exciting. So thank you for all of that. Okay, moving on to number 7, we have a discussion regarding the budget hearing and whether to make public comment from the board. So I think that we can hear from Marcy and Jared on this. I think the lay of the land is that you'll recall that the budget that was submitted by the department was only approved in part. That Marcy will be appearing on March 1st on behalf of the department in front of the committee, the Ways and Means Committee. So that's on Monday. And her obligation is to defend the budget that was approved. So it's to defend what she got in the governor's budget. And that sort of defines her role at that hearing. So I think the question for the board is whether we want to, and in what form, to do more than that. And the sort of rub is that the budget doesn't cover everything they asked for, and the board has agreed to implement the Davis requirements, and the budget doesn't cover implementing those requirements. So we could provide, we could sort of spell out what those are. I guess, Marcy, did you want to add or clarify just to those things?
The only thing that I would clarify or add is that in the attachments that we provided is the assembly agenda for the joint meeting of the Assembly Committee on Ways and Means and the Senate Committee on Finance. It is March 1st at 8 a.m. and we sent you the agenda so you know how to sign in if you'd like to watch or to make public comment.
Okay, so I think this is a discussion item. It's really up to the board. My understanding is we are not the department, so we are, I think it's permissible and maybe our obligation to voice, sort of share our voice about sort of why the budget coming up short on the budget is going to hobble the implementation of Davis. But the sort of practical question I'd like to open for discussion is sort of how do we do that, and who wants to do that, and sort of how should we be, and yeah, sort of the when and how, who, what, where, when, how, related to the board's role. What should the role be? So I'd certainly welcome. I know we have veterans of this process, and I don't want to call on you, but I think I would welcome to hear from you about what you think is the wisest approach.
Madam Chair, this is Joni Eastley. I have one question, and that is, do we know specifically which parts of Marcy's budget request were denied, and why, if we got a reason as to why those were denied, if they were strictly financial decisions or if were some other mitigating factors?
Okay, that's a great question. So Marcy, maybe you could answer that and kind of tick off. I think what would be most useful is to tick off the sort of super high value couple of things that aren't being covered. And of course, obviously, whether you got a justification or just didn't get the funding.
Well, I think, yes, I would love to do that. This is Marcy Reba with the department. So as we all recall, we've been talking about it. There's certain requirements that Davis obligates us to be able to complete. Some of them we did receive funding from the Interim Finance Committee to be able to move forward. And that is that weighted caseload study. The completion of that study was funded by the Interim Finance Committee. There's another requirement that we do the survey that we discussed today, and we received money from the Interim Finance Committee to complete that. The training that we are required to provide, we did receive money to be able to complete that as well. But the concerns that we move into are when we impose our temporary regulations, the compliance with that. For example, we are required under the regulations as well as Davis to ensure that all class members, so all defendants, have immediate access to applications for indigent defense services. All class members must be screened for indigency within 48 hours. We believe that this will increase costs for the county. They may have to enter into a memorandum of understanding or hire additional personnel to ensure that these applications are provided. Attorneys must be present at initial appearance and arraignment. That's a requirement for Davis as well as our regulations. And there's no funding. Some counties weren't necessarily doing that, so increasing their appearance is going to cost additional funding. And then ultimately, within a year of the completion of the weighted caseload study, contracts or contractors or indigent defense providers will be required to comply with those workload standards. And we suspect that that may call for the increase of staff for many of these offices. And there was no funding received for that. What we built this in, this funding, and it's also built in as the maximum contribution. So when this department created the maximum contribution formula, we did ask counties what they expected their future expenses would be. And we did request that as an enhancement to our budget. Obviously, with the shortfall that the state is in at this point in time, base budgets were the priority and enhancements didn't necessarily move forward. So we don't necessarily have any information as to why our enhancement didn't move forward, but the suspicion could be that there wasn't sufficient funding to be able to fund enhancements at this point. So the first enhancement was to cover the maximum contribution formula, which should provide additional fundings over and above the maximum contribution so that counties can actually take our regulations and impose them pursuant to their plans for the provision of indigent defense services. The other enhancement that we requested was to build a complex litigation unit within the Nevada State Public Defender's Office. Again, if you recall, ADKT 411, as well as our regulation, does allow counties the option to opt into appeals and death penalty cases for representation by the state public defender. And there was not funding moved forward on that either.
Okay, that's very helpful. And I guess one follow-up question from me on that is you didn't get the money. It sounds like to the extent it was a justification, partly you didn't get the enhancements. But what is the availability or process for getting more money along the way? As you know, if you don't, you're not going to get it. If let's say you don't get it now, but is there a mechanism to go back and ask for more money as needed over the next years?
So my understanding is that was Chris going to answer that?
Yeah, I just said not really.
So in reading the legislation or the creation of AB 81 in our department, we do have the ability to go to the interim finance committee to request funding if appropriate. But I think that how we're built is to prepare this within our budget, take it to the legislature, and if they approve it, then that's how we would get the funding. We do have the ability, again, IFC, or my understanding there's possibility of one-shot appropriations, but that doesn't necessarily apply to what we need because we'll need this money every year. It's not a one-shot, one-year sort of thing. So that's our understanding.
Okay. So questions, comments, advice from others?
Madam Chair, Chris.
Oh, good.
Oh,
Good.
I had a couple of questions first. Isn't the monitor also supposed to be funded? And that was part of the Davis settlement as well. And that's an ongoing cost.
To answer that question, we did receive approval from the governor's finance office to do a budget amendment, and we did receive approval to build that $75,000 into our budget.
Okay, that helps. All right.
Good.
So someplace other than the two items that you went through are the only two enhancements, because we didn't get 240,000 on something else. I find my notes, but there are quite a few things that I think were related directly to Davis and the lawsuit versus your general operating. Is that correct, or am I not reading our budget correctly?
Jason, are you here? We can ask the management analyst how many enhancements we requested.
I am here, Marcy. Thanks. This is Jason Collett. We had put in into just the DIDS budget. I'm going in to get the exact number. I think there were 3 enhancements, and then the county max contribution wasn't actually an enhancement. It was a item for special consideration. They did roll back each of the enhancement requests from what we had asked for, but yeah, there was some training money, additional training money that was requested. They gave us some, but not all, and I'm not able to get in right now, but
That's okay. It looks like 82,000, I think, and 66,000 were for the training, the enhanced training, annualized and enhanced. Then prison cases, so they don't have to go through the contingency fund process, was eliminated. That reduced your budget by 240. So was that related?
Chris, the prison cases, we have taken over processing the prison cases. They were previously going to the Attorney General's office, and they were processing those requests. We have it was a couple of months ago that we spoke with the Attorney General's office, and they just moved the process to us. That's not something that's built into their budget. It comes out of the statutory contingency fund. So that process is the same. We're just doing the work instead of the Attorney General now.
Is there an assurance that you'll get the money from the statutory contingency fund?
Yeah, it is statutorily mandated that they pay those, but they pay it out of the statutory contingency fund. They didn't want to give us an appropriation to take up additional general funds. So that's something we kind of hope to have happen, because the process to get the payment out for a statutory contingency fund can take some time. Now we're at a point where as they come in, we're processing them, and getting them over to the governor's finance office. Then they go to administrative services division and they process the payments. So it's a lot of cooks in the kitchen that have to, touch the documents before they actually get paid. If they would give us an appropriation, so much like we have for post-conviction, we could actually pay them from what they give us. And then if we exceed that amount, we would go through statutory contingency. And that was our hope with that prison case request.
Okay, so that was denied as well. So you didn't get a line item, basically. You just are doing it status quo, except a different department doing it now.
Correct.
Okay. And then on the maximum contribution enhancement, how much was that?
That request was for, I'm trying to pull it up. It was like $4.8 million per year, and that included all counties.
And this is Marcy, just to add to that, if we only include the rural counties, the request would be 1.8 million.
Marcy,
Okay.
And is there a way to step in on that maximum contribution that at least if we appeal to the committee for the funding for at least the rurals, would that be appropriate and then in 2 years go back for the additional and I don't know.
We believe that could be an argument. The statute says that all counties should be included in the maximum contribution formula.
Correct. Okay. So the approach is still the 4.0. Then the complex unit was not funded. And so that's another piece. And then the county match was not funded. I'm just trying to understand exactly what was asked for that was related to the settlement, which I think gives the chair or whoever testifies the argument to say, you can't treat this as a general fund budget this time around. There are certain obligations that we have committed to in a settlement agreement, and these are the costs associated with it.
Mm-hmm. And Chris, we can get you that information if you'd like to have that information.
Only if we decide we need it. I'm just trying to clear it in my head. And then a second question or third or whatever would be, what is Chairman Brooks's rules this time for how you testify? Do we have any expert witnesses we might want that would help with the settlement argument to help with the pitch that should be in attendance? Are they allowing that? Is it only the chairwoman that can show? I'm just trying to understand legislatively what they've done.
Marcy, do you want to answer that? Do you have?
My understanding is, depending on who you may want to have testify, if they are a nonprofit, for example, David Carroll of the Sixth Amendment Center, he's not allowed to give public comment unless the chair, who we believe is Chris Brooks, requests input from David Carroll, and then they could be prepared to provide input.
Does that apply? This is Laura. Does that apply to written input too?
Yes. He believes that because they're a nonprofit, in order to give public comment, they have to be requested by the chair.
And
that's his organization's guidelines. I remember that, right?
Right.
Can I just back up for a second? I'm sorry, Chris, keep going.
No, that helps me understand. So it's not a Chris Brooks per se. It's a Carroll's rules that he has to follow. Is there time? Do we need him? And if so, is there time for us to request the chair to ask for him?
My understanding is that information, he would be useful, I believe, and that Chris Brooks has the information that he needs to make the request and was at least possibly interested in making the request. He was going to possibly follow through on that. So I think that is underway. And I guess a question for Chris and Laura would be sort of the other thing, which is, other experts or additional friends but also most importantly for today, like the board should, and the mechanism for doing that, for example, is there someone else who wants to do it, or should I submit a letter and then plan to testify, offer to testify if called, sort of how, like, what our sort of setup should be on that so that we can get that going. My understanding is that written comments, or they need to know by Friday at noon. So, and I agree with, I mean, I think, Chris, what you're sort of flagging, right, is we want to be sort of laser focused on Davis as a board requirement and a obligation that needs to be satisfied one way or the other, right? So that we need to be able to, that needs to be sort of understood that we're either seeking the additional funds, which of course we can, or that there's like an understanding that those funds will come through in some other way. But I'm open to ideas. Go ahead, Laura, and then Jeff.
I just have a couple of comments. Marcy, I may have misunderstood you when Chris asked about the full amount versus the 1.8. I feel if we focus on Davis, the Davis case, and it's the 1.8, I feel that shows that we're understanding the constraints of the budget. And we're targeting, as Ann said, we're targeting our presentation to Davis. My suggestion, are you talking, I just hate to sound like my usual self, this Friday at noon? Is that the deadline? Oh boy. I suggest, I suggest that we all agree that the board all authorize a letter of support in our names. So I don't know, I mean, we don't have time to sign it. And that our chair present that letter. I don't know how many people have been watching hearings. I have not. I watched the interim finance hearing, but I have not blessedly watched any hearings yet this session. But they're not going to want a bunch of us chiming in. They're going to want one unified thing. We all agree, I'm assuming, unless somebody on this call doesn't, that we need this targeted Davis money, and we have a good reason for it. And that Ann be the person, and I don't know if your schedule permits that, Ann, but I would hope that you be the person available to testify as our chair and on all of our behalfs.
So that's what I was going to say, Laura. I think Ann would be perfect with that. And you're lucky if you get 2 minutes in some cases. So even it's just a weird session. So I would think having not only a letter that bullet points, they need to understand the gravity of the facts of how this settlement came about and what they risk if they don't at least fund the necessary implementation of it. And I think that's got to be the focus. So those 3 items, so to speak, that were not allocated need to be. I don't know, Laura, maybe we'll see further if Marcy feels that the 1.8 versus the 4.8. And you're right, you can show, hey, we understand the budget constraints. We can at least get the settlement off the ground with the 1.8, but understand that we will come back either to IFC and or a commitment of next session that remainder be funded, something along those lines. I just don't know.
I think the easy way to handle it from the people I've talked to, Chris, it's kind of along the lines, we're asking for the 1.8 not now, we need the 4 whatever, but we get it, so we need the 1.8 now. And that way we'll kind of tag in if we have to go to IFC. They can't bind a future legislature, but we'll tag in for IFC and we can cite to this letter or Ann's testimony next session and say, you know, we tightened our belts, but this is an ongoing need. The other thing is, I think there may or may not be some of us who may or may not have communication with some of the members of this committee, and and Marcy has nothing to do with this, incidentally. It's the board or individual members of the board. But to the extent that we feel before the hearing, we can contact, members of the committee, I urge everyone to do so.
And I have done that.
And we can, so we can use the letter also so that everyone has it and they know what they would be saying, right? That where like these things are itemized.
And Madam Chair, I have a question for
go
Marcy.
ahead. Go ahead, Joni.
Thank you. Marcy, Joni Eastley, my question is, and maybe nobody is going to want to touch this with somebody else's 10-foot pole, but how many of those funding denials do you think, or would it appear that they were made because it was easier to push those expenses off on the counties?
Generally, for other departments, I mean, I'll just tell you, there's no money. There may be money that comes in federally, and it may be available during session more for one like DEETR, new computers for DEETR or something. But I'm telling, I mean, Marcy, I feel pretty strongly, and correct me if I'm wrong, but that this budget, the governor's budget was undertaken on a dire economic outlook, and no department's happy with the budgets, whether or not it impacts the counties, whether or not it shifts to the counties. I mean, Marcy, anyhow, I think it's just in the context that the budget was created, some good things have happened since then, and there may be more money, but they couldn't plan on that at the time they were cutting every department's budget.
I think Laura is correct. This is Chris. I don't think this time any of this was dealing with, let's just cost shift it, which, the ledge is quite good at, and I was as well. That said, it's just the reality. And they probably questioned any enhancement from any department. It's just how the budget process, so that automatically puts a flag on something. So if they're trying to maintain the status quo, which is what they kind of funded basically especially for a new agency, they were appropriate for that part of it. It's just the dire straits that they're in this time around. And if we get rid of the death penalty this session, it'll save you a little bit of bucks. So we can maybe say that in our testimony. Oh no, probably not.
Okay, and then I guess, so sounds like a letter by Friday at noon. I guess I'm curious, maybe Chris G, sort of, is it more likely that they would use the letter to ask questions to Marcy, or that they'd actually want my testimony?
Well, Marcy's in a trap.
Yeah, Jeff, you're right. Marcy can't advocate for what the advocating for. She has to go with.
Her job is to defend.
Okay.
Correct. So you'll have, your letter is just to get people familiar. If you only wind up getting 3 minutes to talk, they've at least got it to refer back to. So in your testimony, what you want to do is be brief and to the point, but what the need is and why the need is different for this organization versus what they would normally look at for an enhancement.
Okay. And then I guess my other question is just, maybe we don't discuss this at the board meeting, I'm not sure, but just sort of other friends, sort of other than, in terms of.
Well, politics making strange bedfellows and all. I wonder if the ACLU knows about this.
I'm sure they do. I know that Franny is on, so maybe we'll get her comment.
I'm sure Holly's out there someplace, or Franny. And yes, they are monitoring it, and we are at risk. And I think that's how the chairwoman starts out: is you're at risk of undoing the data, and then we're back to gazillion.
Yeah, we've held up our end, and then some.
Yeah. Okay. Okay, Jeff Wells, go ahead.
So, I agree with most of everything that has been said here. We obviously covered the fact that Marcy cannot talk about this because the cuts came at the executive branch level, not the legislative branch level, so she can't go around those. So it does have to be the board. there have been hearings up there so far this year where they've given one side or the other all of 10 minutes to try to talk. And so, Laura's going to be right. We can't all be in there. But what Joni asked is the exact fear that all the counties had back in the 2019 session is a couple of the things that are in our temporary rules that make sense for the counties, like the complex unit being able to move death penalty cases over to the state. They can't do that if there isn't a complex unit there to do it. They had the maximum contribution. Well, we can't hold a county to try to meet those guidelines if there's no maximum contribution to be there. So I do think if you could have your testimony, Ann, I think that makes the most sense from the board. At one point, you had to register even to testify. I know they were trying to get rid of that. I'm not sure they have yet. We need to be a little bit careful. Everybody has to read AB 110 unless they put a change in that I think Assemblywoman Dickman was trying to put in. Simply calling a legislator means you now have to register as a lobbyist. They went way, I'm serious, they went way overboard. There's a couple of committees being put together outside that to try to get amendments to fix that problem. And then I do think it's important to try to get somebody in addition to you testifying.
Still going.
Whether that could be Franny or it could be our AG to talk about the Davis case so that we have at least two voices up there saying that. And then obviously if we can get David Carroll, that would be extra beneficial.
And I've already lobbied individually behind the scenes. I've already done that.
Yep.
And what about NACO? Anyone from?
Well, either NACO could do it, or quite frankly, we could have one of the commissioners that's on this board could do it. Either way, we still want to be able to discuss the reliance that the counties made on the 2019 legislation and the expectation of that dollars. It's slightly different than Davis, but it addresses the unfunded mandate issue.
And the big elephant in the room. Sorry, go ahead.
Well, if Dagny would be willing to write a letter for NACO explaining that and be available, if she or one of the whoever, I think that's important. And I don't know if Dagny testifies. I've never seen her testify, but that doesn't mean anything. But I think a letter
she does it all the time.
Oh, good. She shows you what I know.
Yeah. Oh.
And she's very good at it.
Oh,
yeah,
I think she's excellent at I think she's excellent, and she's lived with this so long, years, and briefed her membership. And so, do you want me to reach out to her? I'm happy to.
That would be great.
Okay. I'm texting her now, but I think if can we just kind of agree that in theory, and then everybody can is there any member of this board who is reluctant to say that the board unanimously, blah, blah, and whatever Ann says?
We can't do that because of the open meeting law.
Oh.
No, but if we do it now, it's open.
No, it's not agendized for action. Oh, well, yeah, it is agendized for action, actually.
Yeah.
Mm-hmm.
Yeah.
Is that what you were going to add, Sophia?
Yeah, I was just going to say that. Yeah, as long as you take a vote that that you will present the board. Mm-hmm.
See, there's a method to our madness. Yes, it is agendized. Yes, we can vote for it now. And unless we need, I don't want to be rushing this through, but now I'm freaking out about a deadline. And I'm retired, so I'm not good at that. If we agree in theory that the board right now, somebody's going to form a motion that Ann writes a bullet point letter targeting Davis and explaining, the need for these specific enhancement. And the Dagny thing is a NACO thing, so we don't have to take that up. But if we agree in theory on that, then I would certainly trust Professor Trom to write the letter. And obviously—
Was that a motion?
That's a motion. I mean, if it should be, but I don't want to steamroll this.
Hey, we don't have much time. We have to be steamrollers.
Okay, then I move that the board all agree that that we need to seek, that as a board, we need to seek these specific enhancements from the interim finance, I'm sorry, on March 1st from the money committee, and that the person who is going to convey that message is our chair in both written form, and she'll be available for testimony.
This is Chris. I'll second that. And are you adding, and then any other necessary testifiers such as David Carroll?
Well, I think David's either going to do it or not, depending on what Chairman Brooks follows up on.
Okay.
You know, I don't know that we need board approval for that. I mean, David is going to do it. He's been, you know, involved in this for years. I think that's
From
probably
the beginning almost.
Brooks and Carroll.
Right. I don't think we have control over that. So.
And I don't think we should take a vote on whether David's there, Dagny's there, ACLU is there. Our vote should simply be that we authorize the chair to present both written and oral testimony on our behalf.
I agree, Jeff.
I do too.
Okay. Do we want to vote on that? Everyone in favor of the, it's been seconded already, I believe, right? So everyone in favor of that motion as described.
Aye.
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 Anyone opposed? Okay, so I view that as unanimous approval.
Mm-hmm. And Madam Chair, may I add one comment?
Of course.
So we all know that Marcy has to defend the governor's budget. It isn't her job to get up before the money committee and complain about what she was given or what was cut out, or what we were given or what was cut out. So what I did when I lobbied some folks on that committee, I simply explained my position on this, which exactly matches what the board's discussion just was, and recommended that they ask specific questions that would lead the discussion in the area we wanted it to go. So if other people wanted to do that, that might work.
Okay, that's useful. Any other comments? With this tight deadline, I'm hoping board members will be around for being helpful to get me prepared and to maybe look at a draft.
Yes.
Thank you. Okay, let's go back to our agenda. Let's see. I think we are, let's see. Discussion, Marcy, you're going to have number 8, the discussion of the BDR. You just want to update us on that?
Yes, just to quickly update you, we submitted 2 BDRs. One is to be consistent with our maximum contribution formula and have death penalty be a state expense as set forth in our formula. That has not moved forward. Our second is attached as an attachment to this meeting. It has moved to the Legislative Council Bureau, so we are waiting for them to make their changes, and we are expecting it to come out, and once it does, we will send it to all the board members. We did have to make one change to get this to move forward. Board member Kate Thomas did recommend that we add public defenders to the definition of agency of criminal justice to attempt to allow public defenders to have access to criminal histories. Again, that was limited to just local criminal histories. We did meet with Department of Public Safety, the Washoe County Public Defender's Office. It was unrealistic to go this version. They basically would have had to install computers in every public defender's office so that they could have access to this locals, and it would have been extremely costly, and possibly it would have sunk our bill draft request. So instead, we decided to pull it out, and we are exploring other avenues. We are actually doing group meetings where we are meeting with the Department of Public Safety, IT, public defenders, and prosecutors throughout the state to try and create a uniformity of how the state produces criminal history for public defenders. And we are working on trying to make sure that every public defender gains access to these, and we're exploring matters as to how they could be distributed more quickly. So instead of putting it forward in the bill draft request, we're looking at a process change and actively working with the Department of Public Safety, public defenders, and district attorneys. And the Washoe County Public Defender's Office was agreeable that this was the correct route to take.
Okay. Any comments on that? On the BDRs? That's great. So we'll look forward to that update. Having something move forward. That's great. Okay, number 9 on our agenda, confirmation of the next meeting. I believe that Cynthia sent out meeting invitations, so we should already have this on your calendar, March 24th, 2021 at 1 p.m. And let's move on to number 10, public comment. Anyone who's on the line want to add something? Franny, go ahead. Franny Forsman, sir. Great.
Let me see if I'm just with regard to the money committee. We're on it.
Okay.
We're watching it. We're watching it closely, and we'll be doing something. So
it's hard to say no to Franny.
What? Oh, I don't know about that. I'm a public defender, for heaven's sakes.
All right, that's excellent. So we can look forward to connecting on that as well. Any other comments? Public comments? Okie doke. So I believe that we are done. Do we need to move to adjourn?
No, you can just adjourn.
Okay, let's adjourn until March 24th, but we'll be in touch earlier with the board on coordinating on the testimony, etc. So thank you everyone for your attention and your input, and great work by the department. We're so grateful.
Good job, Ann.
Thank you.
Thank you, Ann.
Thanks.
Thanks, everybody.
Thank you.